The federal government has sought to distinguish the 7 politicians' dual citizenship cases before the High Court, arguing people born overseas should always have known they might be in breach of the Constitution. The Court of Disputed Returns is currently sitting to determine the fate of 7 federal politicians whose citizenship status may have breached the Constitution. Here's what we have learned so far. Most of this we have heard already, but here's a quick recap of the background that was covered when the hearings began in Canberra this morning. Section 44 of the Constitution bans foreign nationals sitting in Parliament. Solicitor General Stephen Donoghue is leading the case for Attorney General George Brandis. He argued that of the 7, only Senator Roberts and Mr. Ludlam should be given the boot. Mr. Donoghue argued that someone who knew they were a foreign citizen, or at least had a sufficiently high prospect of suspicion they might be a dual national, should fall foul of the Constitution. In that respect, because Senator Roberts and Mr. Ludlam were born in India and New Zealand respectively, they could not plead ignorance. Mr. Joyce and Senator Nash both comfortably met the test for dealing with their dual citizenship status by taking reasonable steps to renounce it as soon as they were aware, their lawyer argued. The test for taking reasonable steps within a reasonable time comes from a 1992 interpretation of the constitutional ban on foreign nationals sitting in Parliament. The pair's lawyer, Brett Walker, told the court neither knew they were dual citizens, and said the purpose of the ban was to make sure parliamentarians had an allegiance to Australia. We take the view that there is no split allegiance if we are not aware of one. You can't heed a call you cannot hear. Mr. Walker said to find them ineligible the court would have to find the birthplace of a parent or even grandparent enough to render disqualification. We also heard from Senator Canavan's lawyer, who said the senator has never been to Italy and only became a citizen because of a quirk in a retrospective law. David Bennett said not even the Italians can agree that the law conferring automatic citizenship is valid. Mr. Bennett said to find Senator Canavan was Italian, the court would have to resolve the dispute between the Italian lawyers. He also questioned the documentation used to support the claim his client has dual Italian citizenship. It's quite clear that as far as Italian law is concerned these documents are irrelevant. The Solicitor General drew a distinction between their cases and that of Ms. Waters, who was born in Canada to Australian parents but left before turning 1 year old, never to return. Ms. Waters and her former Greens colleague Mr. Ludlam have already quit federal parliament, and are not fighting the argument they breached the rules. But Mr. Donoghue argued Ms. Waters' election should be ruled valid, and said it was surprising Ms. Waters' lawyers would argue she should have renounced her Canadian rights. In trying to explain how Section 44 of the Constitution should be interpreted, Mr. Donoghue even went into the evolution of British law, as far back as the 14th and 18th centuries, to argue someone had to actively seek out citizenship to break the rules for sitting in the UK Parliament.